What's a trust? What's a will? And which one do I need? Seems to be one of the most common questions that we get when we're talking about estate planning with clients. There's just a lot of information out there, so let's break it down. Now, at the highest level, I say look at a trust and look at a will as both saying who gets what if you pass away. There's more to it, of course, but that's the highest level to look at it. They're both documents that say when you pass, this is who inherits what. Now, a will does that through probate court in California, which we learned we want to avoid. We want to avoid it all possible. And a trust is handled privately amongst family to make that happen. Now, when we're talking about a will, you'll hear it referred to as a last will and testament, a will, a pour-over will, not a living will. That's different. We'll talk about that when we get to healthcare directives. It's a very simple document. It's going to say who gets what when you pass away, who your executor should be. That's the person in your will who you designate as carrying out your wishes. And if you have minor children, it'll also say who should be your guardian, who should be the guardian of the children. Take them in on a day-to-day basis, raise them, make financial decisions for them. Those are the big things that a will is going to do. Now, if we have assets in California that are over the probate threshold, we have to go through probate to carry out your will. So yes, you get to decide who gets what, which is important because at least we're not going according to generic probate law in California. But because it has to go through the probate process, it's not the optimal solution for most people. Now, if you have a very simple estate under the probate threshold, and we just want to make sure that these particular items go to a particular person, a will can accomplish that goal. That's okay. But anytime we are over the probate threshold, we have minor children, or we want to exert a lot of control, that's where a trust is going to be your better option. So when we talk about a trust, you'll hear different words out there. You'll hear revocable trust, family trust, living trust, inter vivos trust if you're feeling fancy. Ultimately, those are all synonyms. It's all the same kind of document. What a trust is at its very foundation, it's your own entity that you create, kind of like a business. Doesn't buy and sell things, of course. It's there. It's in the business of holding on to your stuff that you give it. So you create this entity that we call a trust. You put property into the trust. And then in the terms of the trust, in the contract, we say what should happen to that property. And it's important, the distinction of creating something and putting property into it is important because that's how a trust avoids probate. So remember, we go through probate if we pass away with something in our personal names. That's our estate. We've got to go through probate. With a trust, you create the trust, you put your property in the trust, and then when you pass away, there's nothing left in your personal name to go through probate. It's all in the name of this trust, and within the trust, you've designated exactly what should happen at every step of the way. Now, at their foundation, there's two types of trust. There's a revocable trust and an irrevocable trust. For the purposes of this course, we're only talking about a revocable trust. When most people refer to having a trust, putting together a trust, they're talking about a revocable trust because it's what the vast majority of people need, like 90-something%. It's up there. An irrevocable trust is for very niche planning around estate taxes, around asset protection for people who actually need it, like you've got an 8-figure net worth and we really need to get into asset protection, or we're doing some Medi-Cal planning or special needs planning. Those kind of things, it's all a good option for an irrevocable trust. Most people need a revocable trust. So a revocable trust is what most people need, and it's going to be that entity that holds on to property for you, keeps your family out of probate court when the time comes. But properly structured, it'll do a lot more for you as well. So when we're creating a trust, the first thing we have to talk about is what do we do with property that's put into this trust? Almost always with a revocable trust, legally it's in the name of your trust, but you fully control that trust. So you can do anything you want with it so long as you're alive. Doesn't change your tax structure, doesn't change, filing requirements. Really, no one cares that you have a trust because you treat it as if it was in your own name so long as you live. For most revocable trusts, that's how we set it up. And with a married couple, while both people are alive, It's very easy. Yeah, it's in the name of the trust, but treat it as if it was in your name. A big thing with married couples is, what do we do when one person passes away? Do we continue as the surviving spouse to control everything, can do anything you want, no restrictions? Or do we say, when one spouse passes, we're going to put half of the estate aside for our designated beneficiaries, and that kind of gets locked down in a way, but the surviving spouse can use the other half freely. There's not a right or a wrong here. It's just different techniques that are out there, and it's something a trust will allow you to do that a will won't, or it will allow you to do it a lot more comfortably without being in probate court compared to a will. The other thing a trust is going to do is it's going to provide a lot more protection around incapacity and around elder abuse. And then it has to do with how we structure the definition of incapacity and what the trigger is, how easy we make it for you to be determined to be incapacitated. That might sound scary, but it's really not. It's just techniques that are there where instead of having to jump through the hoops of getting 2 doctors to agree you're incapacitated, we can designate a team of advisors, people that you trust, that know you, and you trust that when they say you're incapacitated, you're kind of starting to slip, but the doctors may not agree yet. That's when you would be deemed incapacitated. Again, just options that are in the trust that are above and beyond what a will is going to do for you. Of course, the big one in trust is what happens when the second person passes away with a married couple, or if you're a single person, what happens when you pass away? The who gets what piece, the sky's the limit with trust. With a will, in general, you're going to designate who gets what, and that's just what happens. It goes through court, and then it goes to that person, and that's it. With a trust, you're going to get into any level of nuanced control that you want. So some people break out a spreadsheet of if this, then that, but if this, then that, and if neither of those, then this third thing happens. The sky's the limit to complexity there. I don't think an overly complex trust is a good thing. We should try to simplify it whenever possible. But if you have very, complex wishes, a trust is going to address those. The other thing it's going to do is it's going to allow you, just on a more basic level, to kind of optimize and protect how things pass to your beneficiaries. So in the case of parents, a common thing will be, I want my kids to inherit, but I don't want them to inherit at 18. A trust is going to allow you to say, you're not going to inherit at 18. You'll have access to a third at 25, a third at 30, a third at 35, so that it's a little bit more responsible ages to inherit. And then we can also say, while you're waiting on the inheritance, you can have whatever you need for your health, education, support, and maintenance. So you're not out in the cold, you just don't get access to the principal until those designated ages. Now, on the note of access to principal, how you inherit through a trust, there's different ways to structure it, and in my opinion, there's better ways than others. Many trusts that are out there say, if I die, give everything to my 3 children outright and free of trust as long as they're 25, as an example. A better option, and how most of our trusts are structured now, a more modern approach, is if I die, give everything to my kids, but it's going to stay in my trust and they'll have access to it according to whatever I say. It can be as simple as they'll have access to it at 25, but it doesn't just automatically come out of my trust. And when you structure it that way, there's different things you can add in there, like asset protection for the beneficiaries. So we give access to the inheritance. We don't mandate that they take it out of the trust. And as long as they leave it in the trust, if they get sued, if they go through a divorce, there's wording in there that's going to give them some asset protection where they're not going to lose their inheritance due to that kind of event. In this section of the trust, it's the most customization for most families. A lot of people just keep it simple, equally to the kids at designated agents, and let's throw in the asset protection piece because it's nice and it's not overly complicated, right? At 25, if they want to take it out of the trust, they can, but they're not required to. But again, this piece to your trust is completely up to you. It's the most customization in any trust document. Whether you do a keep it simple approach, whether you get really nuanced into how someone inherits and all of the what ifs and contingencies, the sky's the limit there. But ultimately, the trust is going to give you way more options than a will would. Now, the next big thing in any trust is who does what. So that's your trustee or your successor trustee. So you're no longer around or you're no longer able to manage funds in the trust. Who's going to step in and carry out your wishes? Now, with the trustee, if we have a family dynamic that we're not really worried about any infighting, kids are getting along, we'll just designate an order of priority. Who's going to serve? However you want to do that. Oldest to youngest, youngest to oldest, who's the closest to you? Doesn't really matter there. We just have an order of priority of who's going to serve. But if we have concerns around, potentially the kids fighting, or we just don't really trust anybody to impartially administer our trust, that's where you can have a professional serve on your behalf, either a trust company or a professional fiduciary that we insert into that role to make sure your wishes are carried out exactly to the letter, and that there's no, indiscretions or infighting that happens. Now, a good trust is also going to have a ton of things that you may not need or we may not foresee, but they've got the tools in there just in case something comes up. So that's things like we have a beneficiary who has special needs or is on government benefits and we didn't plan around it. Let's have a tool in there that we can convert their share to a supplemental needs trust if we need. If the trust inherits an interest in a professional practice or an S corporation or a retirement plan, what do? We've got to have specific language in there that the trustee can deal with the interest without getting into trouble. And as long as you have a properly structured trust, it's going to take care of all of the what ifs, all of the contingencies, and we never find ourselves in court to vet those things. We already have the instructions within the document itself. Now, if you have a trust, does that mean you don't need a will? That's kind of a follow-up, right? No. So if you have a trust, doesn't mean you get away from a will, but the will changes. Okay, when we have the trust as our primary workhorse, we still have a will, but we call it a pour-over will, and all it's really there to do is pick up anything you forgot about and pour it into the trust so that we have a safety net. If you forget about something, you left something in your name, we have something to pick it up and pour it into the trust to make sure your wishes are adhered to. And if you have minor kids, we'll also name guardianship nominations in the will, the pour-over will, to make sure we know who's going to take care of the kids. That person will coordinate with the trustee in the trust to manage finances that are held for the kids. And generally, when we have a trust, we can use a guardian of the person to take care of the kids day to day. We're less likely to need a guardian of the estate, someone to manage finances in the name of the child, which is a good thing because that's the much more burdensome guardianship proceeding to keep up until the child is 18. So that's the basics around what a will is, what a trust is, some of the differences and pros and cons to each. We'll next jump in and we'll talk about powers of attorney, your healthcare directive and your financial power of attorney.